in listen-only mode.
Hello, everyone, and welcome to the webcast. My name is Christine Dursey Davis. I'm the Executive Director of the Ohio chapter of the American Planning Association and Chair of the New Urbanism Division, and I'm your webcast moderator. Today is Friday, August 18th, and we will be hearing the presentation, Zoning Reform in Massachusetts. Where have we been? Where are we going? For technical help during today's webcast, you can type your questions in the chat box found in the webcast toolbar to the right of your screen, or you can call that 1-800 number that's on your screen in bold. For your content questions related to the presentation, you can type those in the questions box, again located in your webinar toolbar to the right of your screen. We'll answer those at the end of the presentation during the Q&A. And I'll ask that if you would like a particular panelist to answer your question, please indicate the panelist's name when you're typing your question in. On your screen is a list of our sponsoring chapters and divisions for 2017. Thanks to all the participating sponsors for making these webcasts possible and free to their members. If you're looking down the list and you don't see your chapter or division listed, we ask that you reach out to them and suggest that they join. Today's webcast is sponsored by the Massachusetts chapter, and you can learn more about them by visiting apa-ma.org. Coming up on your screen is a list of our upcoming webcasts. You can register for these by visiting our webcast webpage at ohioplanning.org/planningwebcast. And to log your credits for attending today's session, just head over to planning.org and log into your My APA account. And then you can search for CM activities either by the event number or today's webcast title, both of which can be found on our webcast webpage, again, ohioplanning.org/planningwebcast. And like us on Facebook, Planning Webcast Series, to receive up-to-date information on our sessions. This webcast has been approved for 1.5 CM credits for live viewing only. We do have some recorded webcasts that are available for distance education credit, and you can check those out again on our webcast webpage at ohioplanning.org/planningwebcast. And we are recording today's webcast. It will be available on our YouTube channel. Just search Planning Webcast on YouTube and we'll pop up. And a PDF of the presentation will also be available at the end of the session on our webcast webpage. Okay, I am now going to turn it over to Christina Johnson to get us started today. Christina.
Hi, good afternoon, everyone. Welcome to today's webinar discussing zoning and land use reform efforts in Massachusetts. As noted, this webinar is being recorded and will be available in addition to the previously mentioned sites, both on the Massachusetts APA chapter and the Mass Association of Planning Directors website. This webinar has been put together to bring planners up to speed on recent zoning and land use reform efforts in Massachusetts. And we also hope to share some policy guidance and lesson learned to other planners across the country who may be engaging in similar regulatory reforms. So we're going to keep this introduction brief and delve right into the presentation. And I'm going to turn over the screen, so to speak, to Steve Sadwick. He is the past president of the Mass Association of Planning Directors, as well as the past president of the APA Massachusetts chapter. He's going to give a little history of zoning in Massachusetts and discuss the progression of zoning reform legislation in Massachusetts.
Good afternoon, everyone. This is Steve Sadwick. As Christina said, I have been both past president of the Massachusetts chapter and of the Mass Association of Planning Directors, and have been involved with zoning reform efforts here in Massachusetts probably since 2002. So I'm just going to run through a little bit of the history of zoning here in Massachusetts. You can see there's 4 significant dates, the first being 1920, when the state first enacted some zoning statutes under Mass General Law, Chapter 40. And that general law is basically statutes relative to local governments. You find 13 years later, they went in and did a significant amendment in 1933 to 40, Mass General Law, Chapter 40, with those sections 25 through 38. And it wasn't until 1954, which was 21 years later, that they created a whole separate chapter in the Mass General Laws, Chapter 48, and it was the Zoning Enabling Act that was enacted by the legislature. And what happened, again, it took another 21 years before they redid zoning again. In 1975, the Chapter 48 became the Zoning Act. And the difference between the 54 and 75 statutes is that in 1966, Massachusetts passed the Home Rule Amendment. And so with the Commonwealth changing to a home rule state, there were no longer enabling acts that were supposed to be on the books. So in 1975, it was set up to address that issue, but we continue to this day to run into problems. So you could see that we ran on a course of 13 years, 21 years, 21 years. If you extrapolate it out from 1975 and did another 21 years, it would have been 96 that we would have, should have addressed zoning reform. But here we are, almost 42 years later, and we're still kind of struggling with trying to do a comprehensive update to zoning. So in the recent past, for comprehensive land use reform, it looks like really in 1999, there was an attempt to address some zoning exemptions that were hitting some municipalities pretty hard. And that led to the creation of a zoning reform working group. And you can see there that the zoning reform working group had put out a product, the Massachusetts Land Use Reform Act, that was worked on from 2000 to 2005. That zoning reform working group included the Mass Chapter, Planning Directors Association, Audubon Society, Environmental League of Massachusetts, Association for Preservation of Cape Cod, the Environmental League of Massachusetts. State agencies were involved in this, as well as representatives of the Attorney General's office, regional planning agencies, and the Mass Municipal Association. In 2006, the product evolved into the Community Planning Act, which we were calling CPA 2 at the time, and that was to try and use the Community Preservation Act, which was the original CPA, as a springboard to try and gain some interest in zoning reform. So you can see here that the chapter ended up hiring a former senator and cabinet secretary who was really responsible for the creation of the original CPA, and we hired him as our advocate to help us knock on doors and get in to see legislators. We worked under the guise of the Community Planning Act up until 2010, and at that point we started working closely with Governor Patrick's administration, mainly through his Secretary of Housing, Economic Development, and they created a zoning reform task force, which included members of the zoning reform working group, but it was a broader scope of stakeholders that were at the table. So Home Builders Association was there, as well as the realtors were at the table. What came out of that zoning reform task force was the administration's Land Use Partnership Act. And at one point, both bills, the Land Use Partnership Act and the Community Planning Act, were being actively heard in joint committees within the legislature. And I have listed there that APA Massachusetts worked with home builders on a side project. We had found some level of consistency with concerns about subdivisions that home builders had brought to the table in these task force meetings. So the chapter created a sustainable neighborhood road design guidebook with significant input from the Home Builders Association. And it was to try and demonstrate that there were things that we could work on in common. And that guidebook is on the chapter's website. Then in 2011, 2012, we came up with this crazy name of Comprehensive Land Use Reform Partnership Act. And the acronym CLRPA was used for a short period of time. But at this point, the Massachusetts Municipal Association had some significant concerns that any type of zoning or land use reform were going to be adding financial burdens to their communities. So they chose to take a different tack, and it's kind of been outside of the core zoning reform working group. So we're still trying to work with them to resolve some of our differences. So you can see here in 2013, we finally did get a vote out of the committee, but could not get it to the floor of the House. And the chapter then turned around and hired a lobbyist, and that was from the offices of Travaglini, Eisenberg, and Kiley, to represent the chapter. We kind of worked very closely with the Massachusetts Smart Growth Alliance and the Metropolitan Area Planning Council to come up with strategies to get in and see the significant players at the State House. I would just say that Mr. Travaglini was the former president of the State Senate, and his colleague Arthur Bernard served as his chief of staff, as well as Arthur serving as chief of staff for Governor Deval Patrick for a period of time. So it was a very well-connected advocacy firm, and they're still working on behalf of the chapter, along with in partnership with Smart Growth Alliance and MAPC. So you can see here in 2014, they actually were able to bring the opposition to the table, but unfortunately, time ran out in the legislative session, and we had to wait to the next session to file a new bill. That new bill was filed as Act Promoting Planning and Development of Sustainable Communities. And in this instance, we chose to file it as a Senate bill, and the Senate President's office, there was a new Senate President, worked very closely with us to hammer out some language, but was also very good at bringing in individual stakeholders and having conversations to put finishing touches on the bill. So that bill actually was reported out of committee, went on to the Senate floor where they passed it, and to some people's chagrin, there was 20 amendments to that reform bill, and it actually changed the scope of the bill that we were championing. And what was a land use reform bill was renamed an Act Promoting Housing and Sustainable Development. And this kind of created some problems within the planning community because it went a little bit beyond the scope of what we were trying to achieve through good planning efforts that were in the original bill that was there before the Senate. So what happened was, in this latest legislative session, 2 bills were filed. The House bill is an act building for the future of the Commonwealth, which was the original bill that the Planning Community Zoning Reform Working Group had supported in the previous session. and was the one that made it to the Senate floor. And the current Senate bill in this current session, an act promoting housing and sustainable development, is that bill that the Senate had amended and had passed during their legislative session. So there's been one hearing so far on the House bill this year in May of 2017, and we're expecting a hearing on the Senate bill coming up in September. And I would say, as it comes from a strategy standpoint, while planning organizations are not fully supportive of the Senate bill right now, we do recognize that it has a path and may be of assistance in getting us some of the reforms that we're looking for. And I will now be passing the presentation over to Lizzie Wyant, who's with Metropolitan Area Planning Council.
Thanks, Steve. So let's see. So my name is Lizzie Wyant, and I am the Manager of Government Affairs at the Metropolitan Area Planning Council. We are the regional planning agency serving the 101 cities and towns of metropolitan Boston. And I do all of our legislative and government affairs work for the agency. I've been doing that type of work for about 10 years now, with MAPC for the past 2.5. So Steve actually covered a lot of what I was going to be talking about, but I wanted to give folks a little bit more background on sort of how the bill is actually moving through the Massachusetts State House. So as Steve said, last year, sort of the highlight is that the legislation itself passed the Senate. And as Steve indicated, the legislation that passed the Senate included a lot of priorities that came from a special Senate Commission on Housing that was created last year by one of our more Boston-based senators, together with one of the senators from Central Massachusetts. So for those of you who are from Massachusetts, it was Senator Dorsina Forey from Boston and Senator Harriet Chandler from Worcester. Created this special commission on housing to kind of look at some short-term, medium-term, and long-term possible solutions to the Commonwealth's housing crisis. And they brought together many of the same advocates who were addressing and trying to deal with the zoning reform legislation as it was moving through. So when that commission came out with their recommendation, which again, many of the same advocates who were working on zoning reform were involved in crafting those recommendations, the Senate, it decided to include some of those short-term recommendations in its version of the zoning reform bill. And so that is the reason that the Senate included those pieces. And it's the reason why I expect that they will continue to be committed to them as the legislation moves through this session. So as Steve said, the bill last year did not get picked up in the House. The House, kind of said that they were running out of time because it was passed in the Senate relatively close to the end of the session. So here's where we are this year. We had to start from zero. So once a bill doesn't make it through a legislative session, you start at the beginning to refile. And so once again, for like the 30th year in a row, that's exactly where we are. On the upside, we have a really strong sense that the Senate is deeply committed to this legislation, and we know that they want to go pretty far in passing what they passed last session. So there are two versions of the bill that were filed this year. The Senate version reflects exactly what the Senate passed last year, including some of those housing provisions that had been included based on the recommendations of the Special Senate Commission. And the House version pulls back a little bit on some of those housing provisions that were included last session. Now, just to make matters even more complicated, the Senate version of the bill and the House version of the bill were sent to two separate committees inside the legislature. And this means that the bills will actually go through 2 separate hearing processes in each branch. As Steve indicated, we have had a hearing on the House version of the bill. The Joint Committee on Municipalities heard the legislation. So that's the House version of the bill, has actually already had a hearing. We had a really strong hearing. And I think one of the things that was most compelling about that hearing is that in years past, we've really focused on bringing people in who could speak to some of the nitty-gritty aspects of the legislation. But this year, largely coordinated by work from the Mass Smart Growth Alliance, we actually brought in individuals who could speak to how zoning reform would affect them on the ground. And so they were telling real personal stories of their access to housing, abilities to get permits, their municipal interactions with developers. And the committee let us know that those personal stories had a really big impact on them. It's a little bit unusual to take a topic as exciting to us, but dry to most others as zoning reform and turn it into something that's really compelling and personal. But I think that the hearing actually gave us a chance to do that before the committee, and they were really grateful for that. So Larry, in a moment, will go into greater detail about the specifics of the legislation. But I want to reiterate that, now is really the time for all of you to weigh in, to talk to your municipal leaders and to talk to elected officials about why it is that the legislation is important and would have a really big impact on both the work that you do and the municipalities that you work in. Legislators really, they get this 80-page bill and it's a lot to digest, but you have the opportunity to make it personal for them. And so as Larry goes through some of the details of the bill, I hope that you'll consider making that connection back to municipal officials in your town and with elected officials inside the State House. I'll be happy to answer after Larry goes through the bill any specific questions people have about how the bill itself will be moving through the legislature. But I do expect that the Senate will take up the legislation sometime in the fall, their version of the bill. Because they have already gone to it in great detail, I think it is likely to move relatively quickly in the Senate. That is certainly our hope. And so I think we would love to be able to be in a situation within the next few months where the Senate has again passed their version of the bill and we're moving to put pressure on the House to continue moving it forward and take it up for full consideration. So with that, I am going to change it over to Larry.
Hey, Larry, don't forget to unmute yourself if you're speaking.
So thank you for that prompt. I did have myself on mute. So thanks to Steve and Lizzie for providing us with a background of the zoning reform effort over the past 20 plus years. I'm with the Massachusetts Smart Growth Alliance as Deputy Director. Before joining the Alliance in 2015, I worked in the Patrick administration and on the 2013-2014 version of the zoning reform bill that Steve was talking about. The Smart Growth Alliance was formed in 2003. It is now an alliance of 9 organizations, and you can see their logos on there. Most of them are statewide advocacy organizations that encompass the various parts of the smart growth world. The Alliance has been privileged since 2013 to be working in partnership with MAPC, APA, and MAPD to pass a comprehensive zoning reform bill. There are 4 campaign goals for zoning reform in this current iteration, the 2017-2018 bill. But before I get there, I do want to talk more about the nature of the coalition. It is a very broad one, although the effort began, as Steve said, in 1999 with planners talking about doing an overhaul of the zoning reform statute. It has widened so that at this point, the coalition has environmental, mobility, public health, and a number of other advocacy groups that are working strongly for zoning reform. And so even though APA and MAPD have a special role in this, it is a very broad coalition. A major focus this year has been engaging local organizations, grassroots activists, municipal and business leaders in the effort. This local effort strengthens our legislative effectiveness because legislators listen closely to people they know and they trust at home. But it's also allowed us to understand the local nuances better, and that makes us as an organization, the Smart Growth Alliance, and the campaign as a whole better. The 4 campaign goals are housing choices, healthy, active communities, helping communities plan for the future, predictable permitting, and they are a very helpful way to organize the many elements of this bill into something that makes sense. There are 25 distinct elements in the bill, and they all fit within these 4 buckets. As both Steve and Lizzie have said, there are 2 bills, the Senate version, which is exactly what the Senate passed in 2016, and the distinct House version. Unless I say otherwise, I'm going to be talking about the House version of this bill. The first goal, housing choices, is really motivated by 2 things. One is that Greater Boston has a housing crisis that calls for increased housing production. But also, everywhere in Massachusetts, there are places where housing diversity is an issue. You are all familiar with the demographic data and shifts in housing preferences that have increased demand for multifamily housing, accessory apartments, and live-work spaces for those in the creative economy. A particular issue for our state's long-term economic health is keeping housing costs from blowing up so much that millennials don't stay here. They are obviously a key for our innovation workforce. But it's also true that most seniors are having trouble in downsizing because they can't afford to stay in their communities. And without places to downsize or accessory apartments that allow them to stay in their homes, they're in a very difficult spot. And that has also had a repercussion on housing supply, as the inventory for single-family homes in Massachusetts is at an unusually low point, because even though the homeowners would like to sell and would get a good price if they sold, they don't have a place that they want to move to. I'd like to drill down more on one of the particular pieces of the housing choice bucket, and that is multifamily housing requirement. The House bill has a general requirement that every community provide reasonable and realistic opportunities for multifamily housing in smart growth locations. Multifamily is defined as 3+ units in a structure. So townhomes or small multifamily homes would qualify. There's flexibility under this provision for the community to decide what permitting mode to use and what density. The wording of this provision is one of the main differences between the Senate and House version. In talking with local planners after the Senate passed its bill in June 2016, we heard loud and clear that there are numerous differences regionally and locally, and that the Senate bill, by providing a requirement that multifamily zoning districts be created at a specified density and using as-of-right zoning, that there were many municipalities that felt that this was overly prescriptive for them. So this House version provides a requirement that applies everywhere, but is flexible. The second key goal is to promote a land use pattern that embraces environmental, mobility, and public health considerations. Like many states, sprawl in Massachusetts has consumed land unnecessarily, increased traffic congestion, and increased greenhouse gas emissions. We can't legislate an end to sprawl, but we can encourage open space residential design for single-family home developments, and we can reduce perverse incentives in our state zoning act for roadside sprawl. Our state's zoning act contributes to roadside sprawl through approval not required lots. No other state has what we call ANR, approval not required. A property owner who has the requisite road frontage can subdivide and create roadside lots with no regulation. Literally, within 21 days, they get a stamp that says no approval required. This is true even if the road is substandard and can't handle the development. The bill would offer municipalities the option to end ANR if they can replace it with a minor subdivision process. Unlike many states, Massachusetts doesn't have minor subdivisions now, and the bill would create that process for the first time. In passing the zoning reform bill last year, our Senate amended what was originally proposed to allow farmers and foresters a limited exemption. They would be allowed to use ANR for up to 2 lots a year. The House bill accepts that concept, but tightens the language to ensure that only genuine farmers and foresters can use it. The third major goal of the legislation is to plan for the future. And in particular, allowing municipalities the tools they need to do that. Many tools that are widely used around the country are not included in our state zoning act. And those include inclusionary zoning and development impact fees. It stands to reason, since the last time the statute was rewritten was 1975, that with 42 years passing, many states have updated their statutes to allow for these 21st century tools. While many communities in Massachusetts work around the omissions, they shouldn't need to do that. And the bill includes a number of provisions that are providing them with those tools. In addition, some of the choices made in 1975 in balancing municipal and developer interests skewed more towards developers. One example of that is our vesting rules, which are too developer friendly. They allow a property owner to have the property rights vested just by submitting any kind of plan for the land, so that even if that plan changes, they are able to freeze the existing zoning rules for 8 years. I'd like to talk in some detail about one aspect of municipal tools, and that is development impact fees. Our state's approach to development impact fees is particularly problematic. They are not authorized under the state statute, and there are court cases that that suggest that municipalities don't have the authority to impose impact fees. So the statute that we're proposing would explicitly authorize municipalities to collect impact fees for off-site public infrastructure. Essentially, we'd like to do what many states have already done, which is to create a clear statewide framework that meets constitutional standards. Municipalities should be able to identify growth areas, study the public infrastructure needed to support that growth, and have a fair plan for developers to pay for some or all of that off-site infrastructure. Although developers have opposed this provision, we think that development impact fees can work for them as well. Many communities are now relying too heavily on discretionary permit criteria. And one of the reasons why they do that is so that they can negotiate mitigation on an ad hoc basis. It would be much better for everyone if developers knew in advance that if they apply for a permit, they would need to contribute X dollars for off-site infrastructure. And they can make the choice then, do they want to propose something in this community or do they want to look elsewhere? The fourth and final goal in this legislation is to provide for more predictable permitting for property owners and developers. Prompt and predictable permitting should be the rule. It works for property owners and developers, but it also works for municipalities to have that clarity. In several respects, our state zoning statute doesn't allow for that, even if the municipality wants it. One particular example is our variance rules. We have a state statute that sets an impossibly high bar for any applicant who is seeking relief. We have had court cases that have interpreted the statute that have made it almost literally impossible for applicants to meet the standards. And at one of the conferences that I attended last year, a lawyer who specializes in doing variances said that she thought that there was probably no variance applicant she's ever seen that would qualify if the state rules were followed. That's led to a situation where municipalities will either follow the literal terms of the statute or tend to ignore it whenever they wish to. And that creates an untenable situation for property owners, developers, and the people who are serving on the boards. Another example is majorities for zoning changes and special permits. Massachusetts, in its zoning act, requires a 2/3 majority for both zoning changes and for special permits. And that binds municipalities, even if they would like to have changes made more liberally. That's especially hard with our town meeting system. For those on the phone who regularly work with their town meetings, I'm sure they've got stories about the difficulty of passing complicated zoning proposals at town meeting. And it also, the 2/3 requirement can be difficult if you've got a board that is consisting of 5 or 7 members. So the 2/3 requirement makes it even more of a supermajority. What the bill proposes is to give communities a choice. They can use anything from a simple majority up to 2/3 for either making the zoning changes or for special permits. For zoning amendments, the default position is at 2/3 unless it is lowered. For special permits, the default position would be a simple majority, but it can be raised up to 2/3. So that concludes my overview of the bill's contents. I've identified the 4 campaign goals, listed the major elements under each goal, and provided more detail about 4 of those elements. As you've heard, the bill is long and complicated, and so I've stopped there and not taken all of us on a death march through each of the provisions. But during the question and answer period, I'd be happy to address any of the elements that you didn't see discussed, and also discuss any of the ones we did cover in more detail. We'll also be offering a comparison chart of the 2 bills that summarizes each element so that if you want to drill down and see the differences between the 2 bills, you can see that. So I'm now going to hand off to Christina Johnson, who is not only our leadoff, but our cleanup hitter. Before doing that, I do want to say that we've really enjoyed working with APA and MAPD, and we look forward to having a really strong campaign this year with them at our side. So I'm going to send us back to Christina.
I'm back. For those that are just joining, I will reintroduce myself. I am the Deputy Director of Planning and Community Development for the town of Hudson, Massachusetts. And as mentioned previously, I serve as the President of the Massachusetts Association of Planning Directors, which I'm going to call henceforth as MAPD, another Massachusetts acronym. For those that may not be familiar with MAPD, we are a 150-member nonprofit organization. Primarily, our members include municipal planners, private sector consulting planners, and other planning and community development professionals, as well as planners from the regional planning agencies throughout the Commonwealth. We do provide a lot of professional development on land use and planning topics, but most importantly, especially for what we're talking about today, we provide a voice for municipal planners on legislative activities such as this one related to land use zoning and community development. And we are taking a much more active and advocacy role with the zoning reform efforts. Thank you to my colleague Larry for delving into the specifics covered by the legislation. If you haven't glazed over yet, congratulations. But I'm assuming most of you are very interested in this topic, so this is very exciting to you. As you heard, there are 2 separate bills being considered, and from the planner's point of view and from what Larry was discussing, we generally support one over the other, and that is the House bill. And I'm just going to give some brief explanations as to why we, the planning professionals, both at MAPD and Mass APA, along with our allied organizations such as the Smart Growth Alliance and MAPC, support the House version of this bill, and why we are using the Senate bill as the vehicle to get those items that we support, those elements we support in the House bill, to be part of a final zoning reform bill. Okay, next slide, please. There we go. Here's the Schoolhouse Rock Dude once again. One of our panelists referred to him as her spirit animal. I think that's really cute. It is a legislative slog, as you know, but why we're supporting the House bill, some of these elements have already been discussed in detail. The House bill, for the first time, gives statutory authorization for form-based codes. This is really exciting for communities that are reimagining the functionality of their land use regulations and are taking bold steps in developing form-based codes. There are some communities in New England that have adopted a more form-based or performance-based zoning. And we think that where communities are developing or practicing form-based coding, there should be some statewide statutory backup. As mentioned by my colleague Larry, during the last legislative session, the requirement that all communities have at least one by right multifamily district became quite controversial and became a lightning rod and really distracted the conversation from zoning reform and land use reform to more of a housing production discussion. Not that that's not a worthy discussion, it just bogged down the process for accomplishing land use reform. Of course, we planners support the development of a wide range of housing choices, including multifamily, but making it a requirement by right is what we thought to be a little bit overreaching. And we think that the House bill softens this requirement and is a much more balanced approach to achieving better housing choices in our community. And more importantly, it's a better legislative sell. Is at the end of the day, I know we planners tend to be very altruistic, but at the end of the day, zoning reform is no different than any other legislative matter. It's going to come down to horse trading and compromise. Some of the other positive aspects in the House bill include vesting and A&R reform. I'm not going to get into the weeds on that unless you have specific questions for me or Larry. We can talk about that as well. The 3 lots in common loophole. Massachusetts has, for those that are from other parts of the country, specifically outside of New England, Massachusetts has some pretty quirky land use practices that are not in other parts of the country. Land use is extremely local in Massachusetts. We don't have really a county form of government practicing land use like in other states. So we have a lot of holdovers from our Yankee past that are still in practice and are still codified at the state level, and A&R and vesting are certainly some of the vestiges of that. Lowering the threshold for special permit. We like how the House bill starts with an automatic lowering and requires communities to opt in to a higher supermajority. We think that's really important, especially with boards that have 5 to 7 members. I myself staff a zoning board of appeals with 5 members. Sometimes it can be quite tough to get a special permit supermajority where it should be more of a simple majority. Also, the creation of 40R districts. That's a specific zoning overlay district specific to Massachusetts. And also with respect to variances, it keeps that substantial hardship standard, but it makes the language a lot clearer for findings. I think we planners with our zoning boards really ride that struggle bus with finding those specific findings related to soil shape and topography. My zoning board of appeals takes an extremely conservative approach in the letter of the law, and that can be a burdensome and intimidating process for the average homeowner that's usually who is affected by dimensional variances, constructing additions and decks and whatnot, encroachments into setbacks. But certainly the House bill clears up some of the language, but still keeps that familiar substantial hardship. So broaching this zoning conversation, I think it's been mentioned several times, zoning is dry. It gets pretty abstract. Only we planners like to talk about zoning. When I talk to my friends about zoning, they leave me alone. So it's not really a topic that lends itself to an easy dialogue. But it's really important, and this is where the Smart Growth Alliance has really helped us, is that they're, and MAPC is telling stories about why this is impactful to everyday life and why this is important to sustainability and creating great neighborhoods. So you're broaching the conversation, initiate the conversation, obviously, with your land use boards, your planning boards and zoning boards. I guess in other parts of the country, they're called planning commissions. Start with those folks first because they have a general understanding of zoning and its application. Especially your planning board would be excited to know that site plan review would be officially codified at the state level. How exciting. But also know your audience. If you're speaking to folks, local officials who are not necessarily versed in zoning, know your audience and don't get into the weeds. Keep it simple. Don't talk about vesting and A&R and getting into the weeds. Talk stories, talk impacts, just as Larry and Lizzie had discussed earlier. What I find really resonates, especially with elected officials and those that may be concerned about overreach or this legislation being anti-development, is emphasizing the good governance pieces of this and the predictable permitting aspects of land use reform, especially with any of the opponents. And of course, we do have opponents in Massachusetts that are very concerned that this zoning reform legislation is overreaching. A couple of the obvious ones, the Home Builders Association as well as the Realtors Association, but also the Mass Municipal Association. As Steve mentioned earlier, we are working to bridge some of our concerns and differences to get on the same page. But really underscoring, this is really about good governance and providing developers with a predictable, timely permitting process. And again, underscoring that land use reform is not anti-development. You need to come out and say that right away. Without developers, our master plans do not come to life without development. So it's very important that when you're talking about this, it's not about a moratorium on development, but it's really about reforming how we grow and how we develop. And of course, engage your local APA chapter, your regional planning agency. Typically, they have the resources to really get themselves actively engaged in the legislative process. Any other allied organizations within your state, for us, it's the Smart Growth Alliance. They can help you broach the conversation. If you're in Massachusetts and you're interested in having this conversation with your local officials, talk to us at MAPD or Mass APA. I am always willing to come and do a little presentation. I'm sure I don't want to volunteer any of the others, but most of us are willing to do that broader outreach and help you broach that initial conversation, because really land use reform is hyper-local in Massachusetts, and the conversation needs to start there. That is really all I have, and this is all of us. If you do have any questions after the fact and you'd like to get in contact with us, our email addresses are on the screen. And with that, I am going to turn it back over to Christine for questions and answers.
Great. And before we do that, I'm just going to quickly verbally turn it over to Lizzie, who has a couple more comments.
Great.
I just wanted to let folks know that MAPC has actually not, our position, we do not favor either of the bills over the other. We actually are deeply supportive of both pieces of legislation, the House version and the Senate version. There are some other items that are included that in the Senate version that we would really like to see move forward. And I wanted to just clarify our position for those of you who are from Massachusetts and listening to the call. Thanks for that.
I'm sorry.
No, that's okay.
Thanks for clarifying.
Okay, we're going to go ahead and jump into questions. The first one, actually, Lizzie, if you want to hang on there, this one's for you. Can we find out what some of the housing amendments were? This does not have to be now live, but perhaps MAPC could publish a white paper highlighting the differences?
So actually, it's probably a better question for Larry, because he kept really close eye on all of the amendments that were filed last session, and has this excellent document that kind of compares what was filed to what ended up being passed, and compares that again with the House version, so folks can kind of see an outline of some of those differences. But I will say a number of things actually came up on the floor debate during when the Senate was considering the legislation. That two of the larger provisions that ended up being added to the bill that weren't actually included in the version that we filed were the multifamily by right, which folks have mentioned before, and an ADU by right as well. And I think we actually expected to hear a lot of pushback about multifamily. We certainly heard some. There was actually a lot of questions about ADU by right. And I'd say in the past couple months, we at MAPC and a lot of other regional planning agencies or sister regional planning agencies across the Commonwealth have done a lot of education with our communities about what the ADU language includes. And just by my own travels around the state and in conversations with other regional planning agencies, I think people are a little softer in their support now, softer in their anger towards the ADU piece that was included. I think people feel more supportive of that right now. And so I'll just see if Larry has anything else to add to that. Larry, who might still be muted.
Thanks, Lizzie.
Sure.
There were three major things that changed in Senate Ways and Means, and those were the multifamily housing requirement was added, the accessory apartment provision was added, and then there were substantial changes made in the variance section that made it much more pro-developer. There were additional changes made on the floor, and I would say the biggest one there was inclusion of a fair housing provision. But Lizzie's right that I do have a detailed comparison of the bill as it was originally filed in 2015 and what was passed by the Senate. So if that's interesting to any of you, I'd be happy to provide it.
And I guess while we're on that, is there a comparison chart for the Senate versus the House versions that folks can get a hold of?
Yes, I believe that it's Christina's plan to include that in what is posted online with the webinar.
Okay, that's fine.
Yes, that is correct.
Okay. And Larry, there's a batch of questions here for you, so hunker down and get ready. The first one is, you had a slide, I think, kind of towards the beginning that says that live work is allowed by special permit statewide. Could it be allowed by right?
Yes.
Okay.
The provision specifically says as of right or by special permit.
Okay. And can you say something about the bullet that said natural resource protection zoning would be established? Can you talk a little more about that?
Right. So what the bill does is define natural resource protection zoning. It does not require it, does not provide any incentives for municipalities to employ it, but like the form-based code, it is defining it in the state statute and in that sense, communicating to municipalities that it's something that's available. One of the issues that arises, despite the fact that we are a home rule state, is that there are cautious lawyers who will advise a community that there are risks to doing something that's not explicitly authorized in the enabling statute.
Okay. Could you confirm that the reasonableness of the ability for multifamily will be further defined by DHCD rules?
So the DHCD can issue regulations that provide more meat to the bones of the legislation. I would expect the DHCD will issue some, whether it's regulations or guidance, to do that. I think that the key to using a general requirement like reasonable and realistic is that it has flexibility to be applied in many different environments, so that what is reasonable and realistic in the Berkshires is different than what is reasonable and realistic in a community that is just outside of Boston.
Okay. Let's see. In the House bill, could impact fees be used to expand or upgrade school facilities? How to deal with this reason towns often have for limiting housing growth?
Right. So the bill identifies specific types of capital investments. Schools are not one of those listed items, but things like water and sewer infrastructure and road infrastructure certainly is an off-site improvement that could be the basis for development impact fees.
Okay. The impact fees are to be based on an infrastructure plan that require updating. What happens if a municipality fails to update their plan? Are the fees void and the municipality then defaults to a discretionary exaction?
The statute would not provide a certain period of time that the capital plan is operative. I think that would be something that could be a back and forth between a developer and the community, with the developer saying that you haven't updated it sufficiently, and that could certainly be the genesis of litigation. I would hope that a community will recognize that it is in its own best interest to keep the plan updated to avoid that kind of conflict. If there were a question about whether the plan is stale, I would think that it would remain in place unless and until a court were to overturn it and say that a developer is not required to comply with it because the plan was outdated.
Okay. Next question. I guess this could be for anyone, but will these bills primarily support production of market rate housing or subsidized or both?
Both. To be more specific, the multifamily housing requirement does not require the production of any particular, form of, that is, doesn't require market rate or affordable. It is silent as to whether, what price point the housing is at and whether it's subsidized or not.
Thank you. Let's see. Under current law, transfer of development rights requires a special permit. Will that be allowed by right? Can a fee in lieu payment be used as part of the TDR as it is in other parts of the country?
I don't believe that the TDR provision that is in the bill changes any of that from the current statute.
Yeah, I think that's right, Larry. I think there's also separately moving research that's being done in the State House with a number of us on separate TDR provisions. So I think that would be outside of the scope of this particular legislation.
Okay, next question. For multifamily housing, since the by special permit language was also included to avoid pushback from MMA or just allowing multifamily by right in one district that must allow for multifamily housing, does this still leave the door open for a great deal of NIMBYism from cities, towns that do not want affordable housing?
So the multifamily zoning requirement in the House bill really provides a general requirement that each community has to interpret in light of its own situation. So it certainly is possible that a particular community can make a decision that is a little bit less on the merits and a little bit more because of local political pressure. The same thing exists with the Senate bill, even though it has a specific requirement for a multifamily zoning district with a certain density and with as of right requirement. It's certainly possible that NIMBYism can push a community to do less than it should under that statute as well. I don't think that there's any legislative solution to NIMBYism. The best solution, and one that we certainly as an alliance have been pursuing locally, is to try to give people who are supportive of good development the tools they need to be as persuasive as the NIMBY forces when rezoning comes up, when a specific proposal comes up for housing. And if they have those persuasive tools and organizing tools, then there can be a genuine community conversation, and the decisions, I think, would be, as a result, better.
Larry, I want to add to that, though. I can tell you during the last session, there were people in some communities just north of Boston that were fighting comprehensive permits within their communities, which are the affordable housing developments that are issued here in Massachusetts. And those opponents in these individual communities were actually attacking the legislation and trying to link it to, Mass General Law 40B, and saying that the bill that the planners were pushing was going to force more affordable housing on the communities. So I'm just putting that out there for any of the Massachusetts planners that are listening, that you have to be prepared for people to attack the bill and call this something that it really isn't. I agree with what you were saying, but people will use this to their advantage to make their case to try and stop affordable housing through their NIMBY tactics.
And I will further echo those comments in what I had said earlier as to why MAPD and Mass APA support the House bill provision for multifamily requirement, because it is a softening and it unlinks the idea that this is about affordable housing and this is about a land use reform, while at the same time giving communities that do want to support a wider range of housing choice the tools in the toolbox to do so. But Steve is absolutely correct. Immediately, the opponents are going to say, well, you're going to force more affordable housing development in our communities, and it automatically gets linked up with the 40B affordable housing statute.
Okay, next question. Although zoning reform is desperately overdue in Massachusetts, I worry that this legislation will increase the cost of building housing in a state already burdened by extremely high housing costs. What do all of you think about this?
I'll take a shot at that. So that is a criticism that's been made by some of the real estate trade associations. And the particular thing that they point to is development impact fees. And I think what they are not appreciating is that development impact fees, although they may raise the cost of a particular, may seem to raise the cost of a particular development, are in the long run a more efficient way of accomplishing what needs to be accomplished for development to occur. And what I mean by that is that there are hidden costs of our present system that have to be balanced against the particular cost of the development impact fees. One of them is that the infrastructure is genuinely needed, and so it has to be paid for by somebody. And if it's not the developer, then it is state and local government that has to come in and provide that infrastructure. That is a cost which indirectly can burden development. A second hidden cost is one of the main reasons why we have discretionary permitting at the extremes that we do in many places is because when a developer comes in to propose something, the community can rightly point to all of the negative impacts and can rightly say that they have to pay the burden for that rather than the developer. And it therefore leads to these very long, acrimonious permitting battles, which occur not only at the local level of the boards, but also in court. And so to the extent that we can make all of these development costs, that is the infrastructure costs, something that is explicit and is transparent, then we're putting the costs in the right place. And by eliminating the hidden costs, or at least reducing them, I think overall the cost of development in Massachusetts will be the same or go down.
It also makes the process a lot more predictable, and there is, obviously, we know as planners, the rational nexus standard that we all use, well, at least folks in other states use, in terms of exacting the impact fees. So again, lowering the cost of development, making the process more predictable are certainly benefits of having impact fees. And also part of that good governance, it takes it into the sunshine. A lot of times these mitigation packages are negotiated behind closed doors, and it's different in every community what's expected.
And I would also add that when you look at housing costs, you really have to focus in on the primary drivers of the cost, that being, labor, supplies, and I think the biggest driver, especially here in eastern Massachusetts, is the cost of land itself. But so you have supply, labor, and land costs, and I don't think that permitting costs are as significant when you compare it to those other three factors. So I don't think that the legislation itself especially at the micro level of one individual house being built, I don't think it's going to drive up the cost of that housing. Over the course of a development, there may be some incremental increases, but I think that really the jury's out on whether or not it's going to be more or less for permitting than it is today.
And the only thing I'll add that just hasn't already been said is that we've heard examples of that need for transparency from almost all of our communities in the MAPC region, that they would prefer to be able to have that, but in their workings with developers, they would prefer to be able to have that kind of transparency that the legislation would provide and reliability.
Okay, thank you. Next question, I think this might be our last. Has there been consideration of how reducing variance thresholds might impact supply of lower value real estate, such as industrially zoned land?
I've been hesitating because I was trying to see if I could play out the different possibilities there. I don't see that the degree of change in the variance rules would affect the value of industrial land. I think that with variances, you are trying to promote district-wide rules that make sense. And if they become antiquated, if conditions on the ground change or the goals of the community change for that district, that there should be a zoning amendment that deals with that. And by the legislation, by making zoning amendments potentially easier by lowering the voting majority if the community wants to simple majority, would allow for more frequent changes of zoning. And on the other side, variances in between changes in zoning are really providing a relief valve for unusual situations given a particular property. And so I don't think that the transition that we're going through from the industrial age and properties that are moving from only industrial zones to more mixed use districts is really impacted by the variance provision that's proposed here.
Okay, I think that's it. I think we're gonna wrap up. If anyone has any other final questions or comments, again, you can contact the speakers, and their email addresses are listed here on the screen. We will have a copy of the presentation available on our Webcast webpage, and I think on the Massachusetts chapter website, and we have recorded it, and it'll be on our YouTube channel. So again, thanks everyone for joining us, and thank you to today's panelists, and everyone have a great weekend.
Thank you.
Thank you.